Okay, let's get right into this. Here's the basic thing. I go live every Tuesday and Thursday, or at least I try to go ahead and basically answer Social Security questions. Now, I'm up on the farm and the internet isn't perfect, but we're going to do it anyways. Now, there's some basic things that you need to know about how this is going to work going forward. Looks like we're having some serious internet problems. Hold on. Let's see if it can recover. Okay, looks like it is recovering now. All right. There are some basic rules for how we do this. Rule number 1, use a fake name when you call in. The phone number you call is the 407-279-1754. Okay, I'm going to put it in the comment section right there. The way it works is when you call in, you use a fake name, no story mode, have your legal question ready, and you got to keep it to about 5 to 7 minutes total for the conversation so that other people can call in. Now, with that said, we're going to try and keep a lot of these legal questions specific to Social Security disability questions. That way, basically, it's on topic for me as a disability attorney. Let's go ahead and basically open the phone up, begin the process, and take some of the earliest calls. Now, with that said, it is super late. We are going live on a day where normally we don't have calls, so it shouldn't be as aggressive today. Let's go ahead and take a look. Phone still isn't ringing. So what I'm going to do is, to make this a little bit easier on me on the 4th of July, we're going to go ahead and wait a little bit. Now, while I'm waiting for the first caller to come in, write your write your questions into the chat section. I'll answer them a little bit later. Here we go. Hi, this is Attorney Walter Hnot, Disability Resolution PA. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Yes, hi, how are you?
Very good, very good.
July 8th. Good. Okay, so I'm calling because I have a question. So
Sure.
I applied for disability, and I also applied for Social Security. Now, my question is, I'm on workers' comp. Now, would I have to wait until my workers' comp claim is settled before I can get a decision on whether or not I would be approved for either the SSI or the SSDI?
No. You can have that come down. I mean, keep in mind, workers' comp settlement, basically, I mean, you're just shooting for SSDI. So when was the last time that you worked?
Oh, God, the last time I worked was about a year ago.
Yeah, so you should be fine. You can continue your claim. There can be a full settlement with the workers' comp group, and you should be fine rolling forward. You shouldn't have to put off the retirement or the disability benefit claim in any way, fashion, or form throughout that process.
Okay, so I can get a decision, without being settled out or workers' comp is what you're saying?
Correct, exactly.
That's not going to affect anything. Okay, all right. Thank you so much, Mr. Walter. You have a great evening.
Thank you, madam. Have a wonderful 4th of July. Thank you. Bye-bye.
You as well. Thank you. Bye-bye.
Bye-bye. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Yeah, I was calling because I'm getting an insurance settlement.
Okay.
And I'm on SSI.
Okay.
And I was wondering if I'm able to receive the money, or will that put me in violation of my SSI?
So it'll put you in violation for SSI or Supplemental Security Income Benefits of the $2,000 resource limit rule. So what you're going to have to do is research what's called the spend down provision, which is where you spend down the money, have an accounting of it so that you can show SSI that you're under the resource limit and should be able to continue to receive your SSI benefits. So that's what you're really shooting for with this situation.
Okay, so as long as I spend it down before the month is over and show them, then I'll be under the resource limit?
Right. They still may hit you for 1 month. It depends on exactly how it comes down. It also depends sometimes as to what's deductible from whatever benefits you receive and how you spend them. But bottom line is that, are we talking like a big amount or a small amount?
No, like $2,000.
If it's $2,000, I mean, you can find deductions and stuff to spend it on to usually, offset that provision. Keep in mind, it depends on how they write up the settlement. You don't want it to be income, obviously, because then it'll violate the SGA provision for the $1,550. But bottom line is, that's a small enough amount where you can find deductibles to usually make it work.
Okay.
Perfect.
Okay. Thank you. I appreciate it, Walter.
Absolutely good, sir. You have a wonderful, wonderful night.
Okay, you as well.
Thank you. Bye-bye. Bye-bye. Okay, let's see if I can find a quick question here before the phone clicks. Do you read my message on Messenger? For Diane Fernandez, I have read. I don't know if I read the most recent one, though. I'll have to check it a little later. Robert said, quick question. Let me see where Robert wrote it. I'm not seeing any quick questions here. So guys, if you can, just kind of shoot to me basically. Okay, my hearing is paused to get additional medical documents in. Should I use a disability expert or rep myself? If you have a disability hearing, you should always get a rep because a lot of reasons. The main one is that you don't get to cross-examine yourself without having an attorney there to go ahead and cross-examine you. So if you go in there and just wing it on your own, the judge will ask you whatever questions the judge wants to, but then there's no other attorney there to go ahead and cross-examine you to get you to correct all the dumb bleeping things that came out. And that is crucial. I mean, they'll also do things where they'll tidy up the ERE, make sure everything's rolling in the right direction, get the amended alleged onset proper, but that's the main reason you want to rep. Here we go. Hi, this is Attorney Walter Hnot with Disability Resolution PA. Let's go through the question real quick. Remember to use a fake name throughout this process. And what is your legal question?
Hi, yes. My name is Elizabeth, and I was wondering, so I'm currently going through the beginning processes of getting a Social Security disability claim.
Okay.
I was diagnosed with CPTSD, acute adjustment disorder, ADHD, severe depression, and I submitted my claim. I'm in Florida State right now.
Okay.
I'm actually meeting with the Florida State doctor on Monday for a review of my case, I guess, or a psychological review.
Mm-hmm.
I'm wondering if I should bring, because I also submitted a few letters from people that have known me going through this transition in my life and how it's affected me.
Okay.
Do you have any pointers for that visit? Should I bring those letters? I'm at the point that this is like, my life was completely destroyed and I don't know what else to do. And I'm trying to fight so hard for this to survive, if that makes sense.
So some of the things you want to do is speak with whoever the attorney or the rep is on what questions you're likely to be asked in the psychological assessment. That's a CDR on behalf of the DDS group that basically sent you out. The next thing is you really want to go ahead and ask that CDR doctor what medical evidence they received, because if they're missing any medical evidence at that CDR evaluation, then you can use that to reduce their overall testimony, because the DDS doctors, right, the medical experts tend to be very biased and anti-claimant. So anything you can do to reduce the weight of their evidence is super important. The next thing is that when you're in there, you have to have memorized some basic things to be able to feed to them. What are your top 5 impairments? What are 2 symptoms/signs for each impairment? What are your, when did each impairment begin? When did each impairment become severe? What are your medications and side effects? And then also, what jobs have you worked with in the past 5 years? You also want to be able to go ahead and go into detail about limitations with what you can't do at home. So just be strong on those particular items. Now, when they do the psychological assessment, it can take 20 minutes, it can take 40 minutes. But the bottom line is your main goal is to get as much testimony that is pro you on the record. So if you think they're there to be your buddy, they're not. You're there to explain to them why you can't do stuff on your worst day, because they're there for a snapshot and you're there to give them a snapshot.
Right, and that's my concern. Like, I don't have an attorney representing me. I've been doing this all on my own, and the reason why I got referred out to them is because I'm going through the state of Florida right now just to get on medical insurance, because I just need so much help.
Okay.
And I can't afford it while I wait for the Social Security disability in the state of Florida. Social Security, I guess, department for their Medicare is who sent me here.
Okay.
And yeah, I used to be a huge time professional, a big community leader in the community and all kinds of stuff, and I could barely even function at this point.
Sure.
So,
So work on those items. You can always go back to the video and click the play button, but those are things that would really super duper help you and get you all in the right direction. Don't be surprised if you walk out of there thinking it's not fair, what a sham, what the hell. Don't be surprised if you walk out of there feeling that way. It is unfortunately a very large part of the problem where the gov doctors, they're getting paid per person and they try to put as many in as they can.
Yeah. Okay. Thank you. No, I haven't come this far to let something like that dissuade me.
Yeah.
I'm
Perfect.
determined to get help. So I appreciate your advice, and I will definitely come back and re-review your answers.
Thank you,
Study
madam.
them for that.
Perfect. You have a wonderful, wonderful night.
Hey, you too, sir. Thank you.
Thank you. Bye-bye.
Bye.
Hi, we are live. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Hey, yes, sir. We called in before, but my question is, my mother and wife's mom passed away, and they had stopped her Social Security one check prior a couple months back because when we moved, that they caught that she never filed for her spouse benefits, passing of her husband.
Okay.
And so I was wondering, considering she just passed away, like this, like will we be able to collect on what she was supposed to be getting paid and all that money that she never got paid for the spousal ones? Does that get go to the my wife? For whatever that's called, like unclaimed something or another, or like.
So, I'm not sure for spousal benefits. Let me see if they have an estate of. Usually Title II benefits have an option there. So they can be paid to a surviving spouse or divorced spouse, when the Social Security beneficiary dies. It can vary depending on because, all right, so here's the deal. With disability benefits like SSDI benefits, if the disabled person passes away, somebody can stand in the shoes of that person and collect the back pay as they go through the adjudication process. So there is that. Let's see. Okay, so let's see. I'm just trying to figure out if that's the same thing, and I might not be able to figure it out on the fly. So let me see what I can find real quick.
Can I set up a time, hire you for like 10 minutes or the time slot or something with you?
I mean, this is what I would say. For this type of question, it's not something that will take me an hour to figure out. Try and I'm going to be super busy over the next weekend, week and weekend, because of trying to catch up from doing all the stuff on the farm. Let me see. And this is going to be basically spousal benefits, and the other spouse dies, and you're wondering if it goes to the child at that point, who steps in the shoes.
Years.
Yeah.
From 2003 to now, and then also my wife, she never did get her. I guess the survivor benefits either from her father passing when because she was underage then. Yeah.
Okay. I'm trying to find an answer real quick, see if I can find a quick statute, but
Okay.
yeah, I'm not sure. I'm not sure, and I have to find it specifically. I know with SSDI benefits it does. It passes on to the person standing in the footsteps of that person, completing the continuation of it. So yes, and what you're arguing is there probably should be back pay for her not originally trying to get spousal benefits, but then the reality is they're going to say, why didn't she file to begin with? So are you saying should a child get the spousal benefits that was owed to her?
To her mother, and she was never able to collect it because the Social Security office never did and send a letter because Dina, she's not exactly bright to begin with, and has no education, never did have an education or anything, but she never got a letter or anything stating for anybody even to know that she could even collect those spousal benefits.
Yeah, but they're going to argue that it's not the requirement, or at least it wasn't the requirement. They did change the rule though. When somebody applies for SSI, they apply for anything they potentially could get. But they're going to say, well, she should have, could have, would have known. She should have filed on her own for the spousal benefits. You're going to argue that she didn't know, and there's no way she could have known. What's going to be interesting is the first question is not who inherits. Oh, say it again.
It was recorded at the SSI administrative office in Illinois that she didn't know. They have that on record.
And that's and that's fine, but that doesn't necessarily mean that the fault then lies with the SSA, because remember the
Right,
SSA.
no, I'm not going to say that. I'm just saying it was recorded through them that she didn't know nothing about it multiple times, that she didn't know anything that she was supposed to even file.
From my perspective,
up on you, and they're not.
Yeah, legal question number one is, do they have a duty to her to release the funds going backwards in time for the spousal benefits, since she didn't properly apply and submit a request form for them? And then the question becomes, if they did, are they capable of being passed down to another person who can stand in the shoes of her for those benefits not received? I'm leaning towards, just from like my gut feeling, that no, they wouldn't owe her any of those benefits.
Okay.
But I'd have to research it and figure it out and look it up. So what I would say is
What
this.
if she was supposed to have an appointment, like,
It's been the 27th.
yeah, the 27th for that, so she can receive the benefit.
So the sister. Wait. So who's having an appointment and for what benefit?
They had separate the Social Security or whatever it is a couple months ago when Illinois taught that she didn't receive her spousal benefits. So for 2 months, she never did get the one check because they had to give her an appointment for the 27th to start the spousal benefits that she didn't get, which I still don't understand why there was such a period why they had to stop her payments or anything, but
so
they did.
They shouldn't have stopped her payment. So you do have an argument and case there for continued receipt. But the bigger question is, could she get access to those additional spousal benefits and then somebody else inherit them? Legally, internally, I'm feeling like it's a no, because they're going to claim that she should have applied, she should have known, she should have done that on her own. Because, they don't have strict liability for, making sure. Well, they just changed the rule on that, to be fair, but still, that's like an SSI rule. Yeah, but it's an it's not for like a survivor's benefit thing. It's like an SSI thing. When somebody applies for SSI, it's an automatic application for pretty much any potential benefit that exists out there that they could go on to. That's not saying that, she was on retirement and then she should have been applied for every single benefit that she could potentially be put onto. And the reason they made that SSI rule and then they codified it is because they didn't want people to go on SSI benefits when they could go on other benefits, because they didn't want SSI recipients to grow, because that's money that comes from the general taxes, as opposed to the trust funds pay for basically retirement, survivors, disability insurance, and things like that. So they wanted the burden to be on the trust funds and not the general tax dollars. But I think with your question, I would have to research it, because A, who has liability for her not properly filing for all benefits? And then B, does she have a legal recourse after death for somebody to step in her shoes to basically inherit the times that she was not paid for those months of her spousal benefits?
Right. Would it matter that she didn't exactly have the mental capability at all to even really know or gain that information at all?
I mean,
it would type on to the person that was in care, or whatever you call it.
It would only matter if she had a duty, or if they had a duty to her. Like, that's the thing, is like, let's say that they had no duty. And I mean, you could say, okay, well, she never could have known, never could have figured it out. And then the argument would be, she wouldn't have known, couldn't have known, even if somebody told it to her. But that all falls onto the idea of, and I mean, I guess your argument is, how many times did she go to the local field office, and why didn't they tell her at any of that, at any point during that time?
Okay. All right. And so, but she can collect, or can get something, the other part, or something.
She was actually getting SSI and SSDI.
Mm-hmm.
Then she was getting a smaller check still. am I still able to collect a survivor benefit off that?
Off of her SSI, no, her SSI and SSDI benefits would end at this point. So, the only question is, would there be liability for the SSA to have to pay any back pay for survivor's benefits that weren't originally paid?
For when you were a child and...
Oh, you mean survivor's benefits? Sorry, when you were, so survivor's benefits for you, the child?
Survivor benefits means she...
So wait, so is the question for the daughter? Is the question for the daughter to receive survivor's benefits off of a parent?
Yeah, off of her, the one when she's underage for the one parent.
Well,
if you don't think that she could do it on the her mom's part of collecting the back part of each survivor. It's very confusing.
I mean, how old is she now?
Now she is 35 now. But at the time of her passing her dad, she was 12, 13. And I know my kids got survivor, was able to get survivor benefits.
Neither one of their parents died.
But no, not survivor. Where they got paid.
Well, back pay was.
Well, from the part when I got into cable, they got another part too.
So, they got child support.
So just to summarize real quick, I mean, there's too many decades in between that where they're not gonna give her funds. You know what I mean? Like, she can go talk to them, but I'm almost certain that they're not going to go ahead and pay out for, multiple decades later, not properly requesting and receiving survivor's benefits, because remember, it's up to like 19, sometimes if there's a school thing, 22, but that she's 30 something, so.
There's probably a statute or limitation.
Yeah, it probably is, but not everybody knows this stuff.
I mean, yeah, the idea is she should have filed way back in the day to collect those. But again, remember, the SSA was terrible at telling people what benefits they needed to file for back in the day, and that was partly purposeful to not have to pay out more.
All right, which could be an argument in court, I guess.
No, they're not going to pay it. I mean, that they're not going to pay. That's way too far back. You run into statute of limitation issues, all that kinds of stuff with that.
Good. All right. Well, were you say you would have to look into it or wanted to look into it and possibly take for a little bit of your time? So
shoot me an email. I'll try to do a quick search when I'm not going live, because then I have both hands just kind of click around at the keyboard and figure things out. But if I can figure it out in 4 to 5 minutes, cool. If I can't, then we'd have to do something else for me to figure it out. Yeah.
Yeah, if we need to pay you, or whatever for your time, I mean, that's understandable. And I'm very sorry that I took up too much of your time tonight.
Yeah, no worries, concern. You have a wonderful, wonderful night, okay?
Hey, you too. Thank you, guys. And happy 4th of July.
Thank you. Happy 4th of July. All right, have a wonderful night. Bye-bye.
You too. Bye-bye.
So I want to do a super thank you to Batty Beth, who did an additional 3 months, which is absolutely amazing. Happy 4th of July, Walter. You are the best. Thank you for helping us out with the informational video. Absolutely, absolutely, absolutely. So what I'm going to do is I'm going to take probably like 1 or 2 more calls. But before I take the next call, if you can, I'm going to take those 2 calls, then throw some of your questions into the chat section. I'll try to answer them really quickly before we close out the show. So, hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Yeah, hi, Walter. My question is, the recent Chevron decision that's been getting so much attention, I've heard so many people say that it's going to adversely impact people on Social Security because, they're going to have judges be able to undo regulations that Social Security has made. And I'm just wondering what specific rules do you think are in jeopardy as a result of this big Supreme Court decision? There have been a lot of other YouTube channels who have been warning about major, horrible problems, but they don't. I guess no one knows exactly what's going to happen, but you're so knowledgeable. I thought you might be able to speculate as to what you think might be the more vulnerable or some of the worst case scenarios that could happen as a result of this.
So I haven't had time to really script it out or go into it in a lot of detail, but to my understanding, basically, this is the decision about immunity related to basically the president's power to be unfenced, if you will, to go ahead and do functional tasks where they can remove laws, they can end laws, they can, basically executive order their way around anything and then not be held liable. Is that kind of where you're, going with it?
I think the Chevron case, there's been so many Supreme Court cases lately, but the one I'm talking about that I think it's called Chevron. It was the 1984 thing that it used to be that any federal agency like Social Security could make their own regulations by themselves, whereas now my understanding of it is that judges can overrule and, basically end any that 5-year rule. They could, apparently, if a judge doesn't like it because a certain organization, files a suit about it, then they could change a good rule like that.
So let me read kind of a little bit about it. I haven't gone into this at all at this point. I need to read and figure out exactly what. Let me hold on. Let me take a moment real quick to just kind of read about what they're saying with this thing. I don't know. I'm going to have to basically dig into this thing and read the actual Supreme Court ruling and see what they're saying. There's a lot of really unhappy people over the past, looks like 5 days. Well, all right. While I'm reading this real quick, give me a quick summary as to what you feel the practical application version of it will be against Social Security benefits.
Well, I don't know because I'm not, by any means an expert in this, but I just Googled the word, I think Chevron deference. I don't know how to pronounce that, DEFERENCE and SSDI. And then, all these things come out, including something from NOSCR, which I've heard you talk about.
Sure.
And NOSCR is saying that it's going to result in all kinds of problems. And then, I just keep hearing so many people saying, a lot, you think of any good thing, the medical improvement standard or the 5-year rule. I'm just wondering if all of these rules could be now in jeopardy and, which ones would be most vulnerable and if there's anything that could be done to stop all these things from happening.
Let's see. God, these quick case brief write-ups are terrible on this thing. I haven't had a really good one yet to actually just dig into. Let's see. Case arose from challenges involving certain fishery management plans pursuant to some group, which requires Atlantic herring fishermen to carry third-party observers aboard their vessels through regulatory plans developed by one of the 8 fishery councils that are then promulgated as regulations by the National Marine Fisheries Service. So the NMFS fully funded the observers' coverage for New England until 2020 when it promulgated a rule approving an amendment requiring fishermen to pay for observers if federal funding becomes unavailable. So basically, they're making them bring an audit group on board, and then they're making them pay for it, which is probably when it went to shit. The fishermen now bear the costs of the observer themselves, reducing annual returns by up to 20%. The MSA did not provide that such costs would be borne by the New England industry, but lower courts deferred to the U.S. Department of Commerce interpretation of the MSA, relying on the Chevron doctrine. The Supreme Court granted a certiorari in Loper Bright on the narrow question of whether the Chevron deference doctrine should be overruled or clarified. Chevron established a 2-step analysis with regard to judicial review of statutory interpretation. At step 1, if the statute was determined to be unambiguous, so if it was easy to read, made sense, an agency was required to adhere to the state's statute's plain language. At step 2, all right, so step 1, it's got to be simply written out. It's got to be easy peasy to understand. And if it is, we apply it. At step 2, if the statutory language was determined to be ambiguous, so if it was poorly written where we can't figure out what to do with it, a court would defer to an agency's reasonable interpretation. Under Loper-Bright, courts now must interpret statutory questions without resorting to Chevron deference. Other deference doctrines, however, including Skidmore deference and consideration of an agency's expertise, are unaffected. Given the unique nature of the litigation under the trade laws, Loper-Bright is unlikely to significantly impact appellate litigation in the trade remedy space, at least in the near term. A substantial portion of trade appeals involves challenges to the sufficiency of agency factual determinations, and thus do not involve statutory interpretations at all. Further, in appeals from the scope determination, DOC has long been entitled to substantial deference with regard to interpretations of its own anti-dumping duty orders without reference to Chevron. The U.S. Court of International Trade and the U.S. Court of Appeals for the Federal Court reached Chevron deference under the second step of the analysis only in rare situations, such as in BMW of North America versus U.S. An appeal, Okay, but what's the Supreme Court ruling on it? Hold on, let me find this real quick. Wiley's International Trade Price consists. So what they're bitching about is, do they rely on a Fed agency or state agency to go ahead and make a ruling if a rule is not written, in a practical application, able to understand how it should be, how it should be applied sort of way? So let's see. Client alert, Supreme Court Chevron decision. Let's see what this attorney had to say. Supreme Court struck down 40 years of legal precedent by invalidating the doctrine of Chevron deference in its decision in Loper-Bright Enterprises versus Raimondo. The Supreme Court's decision will reverberate through blah, blah, blah. Just get to the point of it. Shifting power from federal agencies, executive branch to the judiciary, and presenting uncertainty for employers in highly regulated industries such as healthcare and higher education. So shifting power from federal agencies, so they're no longer the ones who decide how it's going to come down, in the executive branch, which is very capable of being politically manipulated, as it was, to the judiciary, which is less likely to be politically manipulated. Established by the Supreme Court in its 1984 decision, the Chevron USA versus Natural Resource Defense Council and the Chevron Doctrine required courts to refer to the federal agency's reasonable interpretation of law when making decisions occasionally related to the agency's regulatory purview. Okay, cool. Let's scroll down a little bit. Blah, 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 blah. The Supreme Court's decision creates uncertainty for regulated entities across the country, particularly employers, higher education institutions, and healthcare organizations. These entities now have less guidance on how to comply with the federal laws to which they are subject. But that's, I don't know. Should it? What do you think? Do you think it should stay with the judicial department and have judges figuring out how it should be applied, or do you think it should stay with the agencies under the executive division? What do you think?
Well, all I know is that, as you've said yourself, you're always the one person on YouTube who gives the honest truth. And so some people say that, you tend to give bad news, but we will value
not just bad news, colossal, astronomical failures of the system. Yeah. All right. Yeah. Go ahead. Yeah.
So, I guess the only thing I could compare it to is sometimes, so there's this other person on YouTube that, is, usually, gives very happy videos or like things that, good news.
Right.
And, but then he was the one that put out this video recently, somber, that was, and so I think that kind of made me concerned about it. And I thought, well, if the happy person is completely distraught about this and, is talking about it like, life-altering, horrific change, I was just, I thought you would think it's even worse than that because, you don't sugarcoat stuff.
So, I mean, the first thing that I would say is this. I don't think it's going to be that big of a deal because the Social Security Administration is one of the most highly regulated. I mean, there's zillions and zillions. There's an ocean's worth of, procedures, law, regulations. I mean, they have it down to what you are required to do, what the computer system is required to do, what the person touching the computer system is required to do. So I don't think the SSA is going to be put in a situation for the day-to-day application stuff that's not already written out in a very specific way, because I mean, that's what they're saying here. 2-level test. Test 1, basically, you have to go ahead and follow the rule if it's, understood of how you should follow it. If it's not, if it's ambiguous, you're not really sure what to do with it, then you go to talk to an agency about which way it should fold. I mean, they're saying employers, higher education law, healthcare law, client, I guess client law would be the whole, employee/employer/client law. I guess my thinking is this, maritime law, Social Security law, personal injury law, highly regulated, lots and lots of laws, procedures. Social Security has just how many? Yeah, let's see how many laws Social Security has. Let's see how many laws does Social Security have? I'm just curious if they even have this on here. Yeah, it didn't even pop up. Yeah, so it's absolutely astounding. It's not able to be really completely, digested within a lifetime, not just because of what's on the books, but what prior courts have ruled on. And to be fair, there's another thing to this too, which is that when it comes to Social Security law, I guess what your argument is the deference, right? We could look to basically, actually, wait a minute. This just happened. This whole thing I was in a hearing where this was an issue. So I was in a hearing and the judge brought up jobs that were like 4,000 available in the national economy, 5,000 available in the national economy. And my argument is if there's only 4,000 or 5,000 or 6,000 or 7,000 or even 8,000 jobs available in the national economy, that's not enough jobs that a person should be able to go ahead and actually do, right? Or find out there, because there's just not enough of them. You might have to move 4 states over to find one of these jobs. It's just not realistic. So, because not only do you have to have the job available, you have to have the job, as like an industry job. You also have to have the job available where there's no current employee working at that job. And so then you have to have the limitations on what accommodations that person should receive at that job available for that specific job. So when they're under 8,000, I always object to them being used. And so the commissioner came out with an emergency rule through the policy department that said, okay, if there's like 899 if you have any of the 9 areas throughout the United States where they did a census review, the 9 census areas, if in any one of those 9 areas in total that it's less than 1,000 available of that job, then they're no longer allowed to use that job as a vocational assessment tool to basically deny someone. So if you take 999 and multiply it by 9, that gives you the number of what the commissioner would basically go ahead and, essentially reject for jobs in the national economy. Now, under that situation, the commissioner just created agency law because all of the circuit courts were all over the damn place on this thing. Some circuit courts were like, 12,000 available jobs in the national economy is cool. Other circuits were like, 9,000 and under or 9,000 jobs is not enough to consider that job for denying somebody disability benefits. 10,000, 11,000, 12,000, 13,000, 14,000, 50,000, not enough. You had all these different circuit courts coming out with these different decision amounts on what was acceptable. So the SSA, through the agency, through the commissioner, just came out with a rule: emergency release. I think it was like emergency message 28, and that was the decision. Under this new rule from the Supreme Court, what they're saying is the courts would be the go-to person to establish and define what that rule would be. But that's what we already have. If something is ambiguous, the courts all just figure it out by issuing a bunch of decisions. So like if a circuit court releases a decision, right, in one of the circuits of the United States, then, you have all these different circuits, right, throughout the United States, and they all issue different decisions. And then somebody, when there's one circuit saying one thing and another circuit saying another thing, then somebody sues and the Supreme Court takes it up and makes a decision on it. That's traditionally the system we have. And then if the legislature doesn't like that decision, then the House and the Senate will go ahead and make up their own rule, pass it, and that'll be that. Or the agency will go ahead and make a definition of what should be. What they're saying with this is that the agency will no longer have the dictating force because the courts will have to define it. I don't see that as. I mean, look. Think about this. Let's apply the 5-year rule, because they're trying to pass a bill right now saying with the 5-year rule that there could be a percentage that you're willing to reduce your benefits by to receive your back pay and all of your back pay right away. That's that we can't wait act. So that's the new one that they're trying to get through, which is just dead on arrival. It's not going to go through. But the point is, let's say that they try to do that. Let's say the courts decide that somebody should go ahead and have those 5 months available to them, right? So let's say one judge in Ninth Circuit says, hey, I think that they should be able to go ahead and get those benefits during that 5-month period. See, but then they couldn't do that. The judges couldn't do that. The law is already outlined through the legislature which way it would go. So, okay, with this other person that was somber, what was their reasoning that the 5-year rule could be changed by judges if it's already written out and it's super straightforward? Like, we know exactly how to apply it.
I'm not really sure. I don't really know that they gave the specific reason for. I think they were just using that as an example because it was such a recent development.
Okay, so really quick, is this other person an attorney or just like some person?
Well, there was a website that I think did describe, I think the person who made reference to that 5-year rule, I think was a lawyer for the SSA, or so they said on that forum that I saw them on. But the person who I was describing as, a usually cheerful person, I don't think they're an attorney. I think they're somebody who used to work at SSA and now has a YouTube channel.
Okay, but real quick with this one, because this is, and I'll study it. I'll make a video on this. Is this person somebody who currently practices before the SSA, who literally interacts with the judges, who is in the system? Or is this somebody that's just like, they're retired and now they're doing a YouTube channel, get some extra money?
I think the original video I described, I think, sounded like a retired person. I've seen multiple other YouTube videos about this subject, and they all seem kind of, very nerve-wracking to listen to. So.
Okay. I mean, I'll have to research it and go into detail, because to me, if it's a 2-part test, most of the rules with the SSA are not going to be changed. Because if element 1 is strictly that, essentially, they want, okay, so let's say a judge wanted to change the 5-year rule and get rid of it, right? Or extend it, right? Let's go the other way. So they're getting rid of it. You got, now you're not going to have any months that you have to go ahead and lose benefits for the 5-month. By the way, the people watching YouTube right now, the 5-month rule, just so you know what it is where when you apply for SSDI benefits, from the date that you're claiming that you became severely impaired and the SSA agrees that you became severely impaired on that date, for that month and an additional 4 months thereafter, and the month you're found disabled, so technically 6 months, but for the month and then 4 months thereafter, totaling 5 months, they don't count. It's an old rule. It came from insurance carriers way back in the day when they were establishing SSDI benefits in the 1950s. So the bottom line is, it's all codified. We know exactly how to apply it. So the rule, I mean, you can literally look up and read the exact text for the 5-year rule. So let's pull up the 5-year rule. 5-year SSDI weight rule statute. Let's just throw that in, see if we can find it. Okay. Code of Federal Regulations. Okay. Let's see what we got here. All right. 404.315. Who's entitled to disability benefits? Okay. Let's see. Subsection A4. You have been disabled for 5 full consecutive months, or no waiting period is required. The 5-month waiting period begins with a month in which you were both insured for disability and disabled, right? You got your DLI and you're disabled. Your waiting period can begin no earlier than the 17th month before the month you apply, right? Because you're allowed to go back 12 months plus the 5 months that don't count. No matter how long you were disabled before then, no waiting period is required if you were previously entitled to disability benefits or to a period of disability under section 404.320 at any time within 5 years of the month you again became disabled. That's the 5-year rule, where they basically let you not have to get hit with the 5-month rule. Or 2, you have been medically determined to have amyotrophic lateral sclerosis, and we approved, hold on, my eyesight's crap, and we approved your application for disability insurance benefits on or after July 23rd, 2020. Man, that is, you couldn't be more clear than that. That's like super clear. So I don't know how the 5-month rule would ever come into any potential danger of being defined by a judge and potentially increasing it or decreasing it. What's your thoughts?
Yeah, that sounds pretty reassuring. But what about the medical improvement standard? That's been in place since 1984. I think that during CBRs that they can't take benefits away if you're not improving. Do you think that could be made vulnerable by this?
Okay, let's bring up the actual statute. Hold on. My computer is a little bit glitchy right now. Okay, medical improvement, statute 404.1594, medical improvement. Medical improvement is any decrease in the medical severity of your impairment which was present at the time of the most recent favorable medical examination that you were disabled or continue to be disabled. A determination that there has been a decrease in medical severity must be based on improvement in the symptoms, signs, and or laboratory findings associated with your impairments. Cool, easy peasy. Let's scroll past all this because we're looking for where the rule applies, where basically they have to go by the original rules. So let's see, hold on. Yeah, my computer is glitching badly. I don't know if people can see the glitching on your end, but it is literally going in and out, glitching with the screen. So let's see real quick. Medical improvement stand for SSA benefits. Okay, let's see what we got here. Medical impairments. Let me see if I can find this thing. No, you know what? My computer is glitching right now. So I'm trying to find it based off of quick search words. I don't know. I'd have to pull it up, but I don't think. Okay, so assuming that they spell out that they have to use the rules where you were originally found disabled, and I'm assuming that's the issue that you're talking about because you're saying, hey, people found disabled back in the day shouldn't be applied to the culture and the norms and the rules of nowadays, even though the culture and the norms apply, but the rules don't. The rules apply to the back in the day rules of when you were found disabled. So I'm assuming what you're worried about is, will they still judicially, likely at the circuit court level, because if it's at the Supreme Court level, that's a rule no matter what. That's a rule for everybody. But at the district and circuit court level, the federal appellate levels, those would essentially become the new questioned law for that particular area. Now, I have another thing that I'd have to go into with this. The next question you have to consider is, okay, let's assume that we have circuits that are not consistent. They're all over the place, different decisions. And as a result of that, let's say the Social Security Commissioner, Martin O'Malley, has to step in, but doesn't step in. Then this new Supreme Court change is what we already have. Is it not?
That's a good point. Yeah.
Yeah, right, because the circuit courts would just be the ruling authority on it anyways, unless the commissioner of the agency would essentially step in. Now, look, there's a problem with agencies stepping in and just defining rules, which is what we've had, right? The problem with it is that if they go ahead and step in and define this rule to be whatever they think it should be actually applied as, then you are potentially punishing private organizations that are trying to profit off of, basically, a less agency, like a less pro. So let's say that they create a pro-agency rule, which is usually what they do. In that instance, corporations trying to profit will be injured by that pro-agency application. I mean, I could see that in green law day and night, right? Let's say that there's some sort of like green law about cutting down trees. Right. So then the new green laws, you can only cut down these types of trees because the agency head said that that's all you're allowed to cut down if you go ahead and, lease this land in this area from the federal government. Well, then all of a sudden that decreases essentially the profitability of that corporation to cut down more trees and create more wood and create more lumber and then sell them. So you're removing a potentially biased party for a federal circuit court decision on what the rule should potentially be on appeal. Of course, you'd have lower court standards, but they would ultimately appeal it up. And then that appeal decision, whatever they decide in that court, would hold. So do you think it would be wiser to have the judges decide what the application of the rule should be so that it's potentially more neutral in its application? Or do you feel that the political environment of these agencies would potentially be better with the sway and the swing of whoever's president to give the definition of what, the rule should be?
I just don't know. I don't know enough about it. I'm not sure.
Okay. We both need to read up on this and do a video on it. This is important. I will read up more on it because it's interesting. When I first went to go read it, my thinking is that when it comes to this Chevron decision change, I have to see I've got to read the Supreme Court ruling, which sometimes is so amazing. Sometimes the Supreme Court justices would give us the most beautiful briefs. God, they were just so incredibly well written. They were brilliant. And sometimes we get these briefs from the Supreme Court, and they are written as if a British man hated the world and wanted to punish us with his diction and syntax. So I will have to read it, good sir, and then I'll get back to you. But I will do a video on it, I promise. Because at the end of the day, I don't think the Social Security Administration, when it comes to this application, is really going to be effective because their rules are heavily written out. Do I think that the agency heads should be able to define things? Yes. But do I think that the agency heads should have absolute power to give direction and final ruling? No, I don't think agency heads should be judges.
Mm-hmm.
Well, let's say that you get arrested by the FBI and the FBI has to decide your fate, and the agency head of the FBI is the one that's going to decide your case's fate.
Mm-hmm.
That would be a no bueno, class 5.
Yeah.
Okay.
I see what you're saying. Hey, by the way, speaking of that, I was talking about the medical improvement review standard in the CDR process, where they have to show medical improvement as opposed to essentially making you have to reapply for benefits from square one every 3 years. Do you feel that is an example of a rule that could potentially be in jeopardy, not necessarily because of the Chevron thing, but because of the fact that there are groups out there, such as, I believe, the Heritage Foundation, that specifically lists that among many other reforms that they want to do as part of Project 2025?
I reached out to them on a couple of things to get a comment from the Heritage Foundation because, they tend to be a little bit out there. And I wanted to get their side of it. They have never responded to me that they would be willing to come on the show or even give me a comment. So my feeling, and so what you're saying is during the 8-step sequential process via CDR, when the element requires them to go ahead and show medical improvement, can they change the rule to make it easier for the SSA to go ahead and basically make you either file all over again, kick you off the benefits, or basically make it so that, and you know what I think the real question you should be asking is the medical review change, right? So how much less disabled are you? We don't really have a great definition for mild, moderate, severe, and extreme. So in that regard, potentially this is where you would demand the head of the SSA, the commissioner, to give further clarity. But how do you clarify that, right? Severe. There's too many types of impairments. Pick out 4 different impairments under the respiratory category, cardiovascular category, musculoskeletal category. Pick out 4 impairments from each, and they would all have a different severity standard for what is actually severe. Because all these impairments are just different. Some of them you can group together: anxiety, depression, panic attacks, stuff like that, under the 12.0 for the listings. But, other ones, Musculoskeletal, some of these bones, whether they fused, is a very different standard than whether or not there's a spinal column issue when it comes to, interaction with bony tissue and your spinal cord.
Mm-hmm.
So, because, look, if you look up the definition of what is a severe disability here, SSA definition of severe disability. Let me read you the exact thing. It's crap. It's total crap. But like, how do you make it better? That's the problem. Hold on. Let me scroll. God, this computer, something's wrong with my computer. It's literally going in and out. Okay. All right. Basic definition of disability for adults. Wait, is this the severe one though? Because this might not be the severe one. Yeah, okay. All right, here we go. The law defines disability as the inability to do any substantial gainful activity by reason, which is step 4 and 5 analysis, of any medically determinable physical and mental impairments, which can be expected to result in death or which has lasted or can be expected to last for a continuous period of not less than 12 months. Got it. Simple, easy worded. To meet this definition, you must have a severe impairment or impairments that makes you unable to do your past relevant work, element 4, or any other substantial gainful work that exists in the national economy, element 5. If your severe impairment does not meet or medically equal a listing in Appendix 1-2, Subpart P of Part 404 of this chapter, we will assess your residual functional capacity as provided in these other sections. That's not crap. Hold on, let me get you the actual crap definition of severe. Hold on, here we go. Okay, here we go. Proof of severe impairment, the SSA defines as a condition that significantly limits the individual's physical or mental abilities so that he or she is unable to perform basic work activities. Severe impairment can result from a single condition or from multiple impairments that are individually less severe, but when taken together render an applicant unable to work, which is your whole RFC vocational allowance. This I could see as an issue. Because remember, sometimes when they define severe, it's the omission or it's the what would not be considered severe. And then we gauge severe based off of what it's not. So like, okay, non-severe impairments. An impairment or combination of impairments is not severe if it does not significantly limit your physical or mental ability to do basic work activities. Basic work activities. When we talk about basic work activities, we mean the abilities and aptitudes necessary to do most jobs, your SVP 1 and 2s. Examples of these include physical functions, capacities of seeing, hearing, understanding, carrying out, and remembering simple instructions, use of judgment, yada, yada, yada. Okay, so here's the definition I was looking for. Hold on, here it is. And keep in mind, we're all winging this. Like I'm winging this right now. I haven't done digging, but this is a fun, I enjoy this. This is a little mental escape. Let's say, okay. Although an impairment is not severe if it has no more than a minimal effect on an individual's physical or mental ability to do basic work activities, the possibility of several such impairments combining to produce a severe impairment must be considered. Blah, 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 blah. That was not the definition I was looking for. Hold on. I would be faster, but my computer is not typing what I'm typing. Okay, here we go. To be found disabled, an individual must have a medically determinable severe physical or mental impairment or combination of impairments. That means the duration requirement at step 2 of the sequential evaluation process, an impairment or combination of impairments is considered severe if it significantly limits an individual's physical or mental abilities to do basic work activities. An impairment that is not severe must be a slight abnormality or a combination of slight abnormalities that has no more than minimal effect on the ability to do basic activities. Let's see. Okay, here we go. So DI 24505.005 sets forth the various considerations in evaluating severity issues. It confirms that although an impairment is not severe, if it has no more than minimal effect on an individual's physical or mental abilities to do basic work activities, the possibility of severe such impairments combining to produce a severe impairment must be considered. That's where they go down. Let's see. Hold on. Okay, here we go. A severe impairment is one that imposes more than minimal restriction on a person's ability to engage in basic work activities. That was Torres v. Shalala. Fourth Circuit law provides that impairment can be considered as not severe only if it's so okay. So yeah, I could see this rule. I could see this being a problem because this is not well outlined. Yeah, I could see this being an issue. That's an interesting thing. But I mean, again, we would expect the commissioner to just come out with a rule, and the commissioner retains their ability to create SSRs, which are Social Security rulings. And once the commissioner comes out with an SSR, that's the new rule. We go by that unless Congress creates a new one or the Supreme Court. Wow, there are I gotta say, Walter Scott, thank you for the $4 donation. That's absolutely amazing. That's very, very cool. Deb Carter gifted a membership, which is super awesome. Thank you, Deb Carter. That's amazing. Let's see what we got here. Lovejoy did a $1.99 donation. That's awesome. You rock for offering this service to those in need. Thank you. Rose, wow, gifted 10 Social Security Disability Benefit video memberships. That is amazing. Does anybody know? Okay, yeah, it looks like they were gifted. That's incredible. Rose L, thank you. That's absolutely amazing. Absolutely amazing. Wow. So your point is the definition of severe is not well outlined. And as a result, the court system has to go by each impairment and usually remand it back to appeals counsel, and then it gets remanded with case consolidation back to the ALJ hearing level. So your point is, could higher up courts, through the Chevron, dictate the definition of a severe impairment? But to be fair, severe impairment has been defined by courts all along, and the Social Security Commissioner hasn't given us a really clear and direct and obvious definition of severe, because how the hell could you? There's just too many different types of medical impairments, and there's no way to be like, well, this is the E equals MC square of severe for all of them. So I guess my question to you would be, even if the judges try to define severe, why would that be a bad thing? For that case-specific situation.
Well, I've heard people say that the whole reason that they started the medical improvement review standard is because I understand prior to that they were just kicking a lot of people off disability without a lot of reason, and I thought the whole purpose of the CDRs was to try to create the standard by which there would have to be medical improvement for that to happen. I thought that was a congressional action that perhaps might be less, if it was passed by Congress, then maybe it wasn't a SSA regulation.
The medical standard used for the 8-step and the CDR?
I think they call it the MERS, M-I-R-S.
Yeah, sure. How much have they, are they likely to improve, all that jazz. So what you're saying is the little tiny clicks in the dial that go left and right as to whether or not somebody has improved or not should be defined by the agency head, even though they're not very well articulated, and therefore fall into the second element of this two-pronged test where it's not well defined, leading to judges making the decision on if that person was really disabled, or in your case, retaining their disability due to the severity, whether they had medical improvement. Is that what you're saying?
I discovered that because if you look at Project 2025, they list all these different plans that they want to do to change disability as we know it. And that was one of them, was to eliminate that. And I think another one was to include unearned income as part of SGA. So if you got, dividends, that would count towards SGA. And I think there were a list of 16 ideas that they want to do too. I think one was to establish a flat benefit so that even people on SSDI would only get, $900 a month as a flat benefit instead of, the range that they can get today, like a flat anti-poverty benefit, they call it.
Well, there is a flat benefit already. I mean, there is, because SSI boosts people with their SSDI retirement to $1,000 anyways.
Mm-hmm. So I guess I was just wondering, if the administration changes and the Heritage Foundation plan, moves forward. I'm just wondering how likely you think all of these changes would be able to happen.
Trump is afraid of Social Security, but the commissioner he puts in, like he did with Saul, was not afraid to change things and be very negative towards beneficiaries. Saul was what I would say one of the most negative against claimants commissioners that we've ever had at the SSA. We've got Commissioner Martin O'Malley now, who's one of the most positive pro-claimant commissioners. So I'll do a video on Project 2025. I'll do a video on the Chevron decision. I don't think courts having the power to decide if an agency is doing the right thing is a wrong thing. I think courts should have the power to decide if an agency is doing the right thing, because the one judge you don't want is that if an agency is the one defining if they're doing the right thing or whether a law should be a law, is the agency head. Because you can't trust an agency head, especially of the largest agencies, because they're cabinet level position people put in place by the presidential leader.
Mm-hmm.
I got to take the next caller, but this was a really interesting. I'll do some videos. I'll do a video on Project 2025. People have been, really on me about it. I think people felt like I was beating too much up on Biden, but he's the one in power right now. Like Trump has no power; it's all Biden, So, but I will do a video specifically on 2025. I will do a video on the Chevron decision, and then we'll kind of go from there. But yeah, man, to me, I don't think the Supreme Court went the wrong way, but I could change my mind because remember, when I read this stuff and think this is the way, and then I take a shower. God damn it! Sometimes I end up the other way. So, yeah. Yeah, but sounds good. This is a good yeah. All right, cool, man. Next couple of days, next couple of weeks, I'll do a video on them.
Yeah, when you do the Project 2025 video, you'll notice there's 16 very specific suggestions that they have that they want to do for the SSDI program reforms. So
I've reviewed them before. I just never took the Heritage Foundation as a very serious, likely to happen group. And then they overturned the, historic Roe v. Wade legal foundation. And then I was like, oh shit. I just never thought that was going to come down. I never thought the federal government was going to hand that to the states. And I still stand by, I don't know how women ever let that one slide through. I mean, I don't. That was a sledgehammer to women's rights right there. I don't know how they ever let that one go through, and I don't know how we've had all these years thereafter without a legislation actually changing it back to that. I was blown away. You took women's rights from they're doing great down to now the state gets to figure out what they do with their bodies. It's. Maybe I should more seriously look at the Heritage Foundation. Maybe I should and see what they're saying. Just so you guys know, if you don't know, the Heritage Foundation, for those who are watching right now, essentially is a very, very right wing version of the Republican Party. They are kind of like old school Republican, like this is the way, the Bible is the way, Christian Republican kind of, it's not like the modern person, but it's like old school attachment. And they've kind of what would you say? Would they have, they've fallen from popularity across the spectrum? Or do you feel like they're still, they're still popular against hardcore Christians, but they're not popular with, like, I would say, middle ground Christians? What would you say with that?
With who?
The Heritage Foundation, as to where they stand, which popularity group is going to back them, things like that.
They seem to be, from what I could see, very influential with the MAGA wing of the Republican Party, which, they seem very, very influential. And it seems like they advocate for a lot of things. They want to eliminate, I think, all of the grid rules, is completely eliminate all of them.
I guess from my, but here's the thing. Like, I think with the MAGA movement, you have, all right, so the Republicans rely on massive groups. They rely on Christians. They rely on old people. You know what I mean? They rely on like massive groups, whereas Democrats rely on a lot of small groups. And so, minority groups, things that are not traditionally the norm, like, people who are, gay, lesbian, etc. They rely on, the Jewish faith for the most part, although there's a bit of a swing going on with that. So I would say this, I think the MAGA group is, I don't think a lot of the Christians in there are super down with the Heritage Foundation, but I do think that there's a good chunk of more strict old school Christians that definitely would follow the Heritage on their ideology and thought process. But, you are right. They do seem to get a lot of attention from these Republican politicians when it comes to basically airtime being presented by the Republicans. It does seem like they do give them a lot of airtime, even when maybe more of their population does want what they want. Although it's hard to imagine all of the cuts that the Heritage Foundation talks about being popular with Americans,
Yeah.
I'll do a video on it. I'll do a cross-section analysis of who's basically into the Heritage Foundation. They have never reached back out to me to at least come on the show. I wanted to interview them. I know they came out with some stances that I specifically reached out to them for. And I was like, hey, why do you guys support this? Can we talk about it on the YouTube channel? And they never reached back out. So for me, if a group isn't willing to reach out, I kind of wrote them off as being just, wrong and knowing they're wrong. And because, if somebody's not willing to talk about what they believe, like you have like people like Jordan Peterson who will go out there and talk about what he believes, whether right or wrong, and fight a battle over it. And then you have other groups like Heritage Foundation where I reach out to them and they're like, nope. And, they could have anybody. They could have anybody from their group go ahead and go on the show. It doesn't have to be their head president. Could be somebody else. But still, nope, nobody's coming in. All right, cool, man. Well, any additional thoughts before I pop over to the next caller?
Wow, that's a pretty loaded question. I definitely agree with the other people that you should run for president or, because you're so talented. So I guess that would be the thought.
Thank you. I think I'd have to be at least 80 to make it. I'd have to, the funny thing is too, we expect these ancient individuals. Yeah, and that's the thing. If you go back to like movies, right? The movies always show like the council, and the council is always filled with like the oldest individuals that are just falling apart, from Dune to The Matrix to whatever, all the movies have that. And what I've realized is that we are hoping that the oldest people were good people, and that those good people didn't just learn how to fake it to make us feel like they're wise. But at the end of the day, they understand people more than most. They just don't understand the modern needs of future generations, which became more prevalent as technology got faster and faster and just started ripping through society and its culture. So, remember back in the day, like if you go back, let's say 50 years, you had people who by their age alone became the authority on a subject, even if they were dead ass wrong. Like the age was the dictating factor on correctness. And then, of course, science debunked a lot of that stuff and then moved us away. And then the internet became the ultimate debunking platform. The internet was the ultimate, like, let's talk about it platform. And so by and through that, older people lost a lot of their like generational wisdom that must be dictated as the rule of law. And so, as a result of that, we now have lots of younger individuals, making these big steps. But I will say this, I think, to be fair, one of the problems with becoming president or a governor or any one of these things is that they just destroy your name in the process of it. And like I see these other YouTubers that are basically running for office here or there, like Meet Kevin and stuff like that. And I look at that, I'm just like, dude, if you do that, they will destroy your name. And they will find any way and anything on you. They will manipulate things to go ahead and basically make you out to be a monster unless you support funding their agency. Like, never forget, like the power of the United States government is in the agencies that have the capacity to control other agencies. Like, that's real power,
Yeah, good point.
So like imagine. Like, who would be more scary, the head of the CIA or the head of the FBI? Who would be more scary, the head of the CIA or the head of the SSA? Who would be more scary, the head of the FDA or the head of the SSA? And you start to realize that the one that would be the most capable of manipulating, not just the American people, but also the agencies that are, basically interacting with them, the one that has the most capacity to do that is the one that has the most pull when it comes to the president, who has the most pull for demanding from the president more money, which is what they did to Nixon, and many other presidents before that. So,
yeah.
So, but I will do videos on those, but I will catch you later. You have a wonderful, wonderful night,
Yeah, and I'm sorry that I took up so much of your time. I apologize about that.
No, this was great. I really enjoyed it because usually it's just me answering like itty bitty questions and zippity zoo. Oh, I'm going to take this call real quick. You have a wonderful, wonderful night, good sir. Thank you. Thank you. Bye-bye. Hi, this is Attorney Walter Hnot. We are live. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Hi, my name is Jennifer, and my legal question is this is you did a video recently about the change with like being able to go back in time.
Yes.
And I just had my second administrative law judge denial.
Okay.
And I'm wondering, so does that mean that I would be able to go back to the first denial, or that I should go on to the Court of Appeals?
I mean, you could appeal it, or you could do a new claim back to the original AOD. It depends on structurally where you think the approval will come from, but I think it had to be denied before the 22nd of June, and I think it had to be a denial related to Element 5 and Element 4 application. So with your denial, was it like a denial related to the 5 versus 15-month waiting period, or was it a denial for something else like non-severity?
Let's see here. The first one or this last one?
So here's the kicker. Do you have the denial letter from the ALJ?
I have both of them. Yep.
Okay. So what I would say is this, over the next week, I'm going to be super busy. Try and email them to me and then just catch up with me like Thursday of next week. I'll try and take a look at them and then figure out whether or not the application process applies to you, because you have to look at whether or not. So it's a couple of things. A, you have to look at whether or not medical vocational profile would potentially apply. That's like a special one, the arduous work one, the, lifetime, achievement of that, or a lifetime work in that particular industry. You have to see if one of those is going to apply, and you have to also see whether or not you received a denial at step 4 as a result of the 15 years, or versus, basically they were able to apply skills or things like that that then got you denied in step 5. So it's Let me read them because I have to read through the portion of the brief that specifically goes through vocational jobs that they proffer that you could potentially do. And how old are you current, or what is your current age? You don't have to give me the exact year. You can give me one above or one below.
45.
So yeah, so you wouldn't have any special medical vocational profiles. You also wouldn't have any of the grid out options. So it's less likely at that age that you'd be able to use this rule to go back in time, but I can read it and figure out whether or not this is an appeals counsel or refile under that special rule that they're allowing as a result of, basically going back in time to the original, filing date / alleged onset date.
Okay, because I have a representative. I found you because he told me that, he told me he couldn't give me any legal advice. The one time we talked before this last hearing, it was a week before.
That's weird.
And it was about my case, and and he wants to continue on, and I really don't feel comfortable with that. But and like my IQ is 82, which I didn't even know until I read my denial from the first hearing, and I guess I forgot or dissociated. And I don't remember being at the first trial. It's from 2018. And there's just a lot of things, the new administrative law judge said that there's no evidence of that when it says in the first denial that I had a full scale IQ test and was 82. So it's just like there's a lot of things like that.
But even if it was 82, you got to keep in mind, they're looking for 50 to 60 and 60 to 70 in application of the listing. So, it might slow you down. But, if we go to, let's see, SSA listing 12.05, and we go to mental disorders, and we clickety-click down here to intellectual disorder, what they're looking for is, okay, here it is. Subsection B satisfied by 1, 2, and 3. So you got to have all three elements met. Significantly sub-average general intellectual functioning evidence by A or B. So A or B. So, A, a full scale or comparable IQ score of 70 or below on an individually administered standardized test of general intelligence, or B, so it's either A or B. B, a full scale or comparable IQ score of 71 to 75, accompanied by a verbal or performance IQ score or comparable part score of 70 or below on an individually administered standardized test of general intelligence. So that's A. Or sorry, that's one, right? So you either choose A or B, but that's one. You got to have one or the other. Now we go to 2. You have to have 2. Significant deficits in adaptive functioning currently manifested by extreme limitation of one or marked limitation of 2 of the following areas of mental functioning. So you got to have an extreme limitation in one of these categories or a severe limitation in 2 of them. So the categories are understanding, remembering, or applying information, interacting with others, concentrating, persisting, or maintaining pace, or adapting or managing oneself. And then number 3, so remember 1, 2, and 3. This is number 3. We got to have 3 met as well. The evidence about your current intellectual and adaptive functioning and about the history of your disorder demonstrates or supports the conclusion that the disorder began prior to your attainment of age 22. Okay. So basically, and that's, they get a little wobbly on, that one because, the reality is, how do you prove that somebody's had a low IQ unless they were in a car accident that then created a low IQ? If they had a low IQ when they were 55, they probably had one when they were 12,
Right. I mean, that's not even the main thing with that's just one of the, the weird conflicts in the denials, I didn't even know I had an IQ, a full scale IQ thing until this year. When I was reading my old denial letter, from my first denial. So I have PTSD. I was drugged and taken and raped by 4 men Halloween of 2006, and that's the last time I worked.
Okay.
Was September of 2006.
Okay.
And I also have bad generalized anxiety disorder, panic disorder, and I have ADHD combined.
Okay.
And then I have some physical things as well, like gastroparesis and arthritis in my spine, in my neck, and stuff like that. I get nervous and then I tell them like this. I'm sorry.
Yeah. So, I mean, the thing that I would say about this is that, I mean, it sounds like a good windup of potential options for vocational allowance. Those are just tougher to get right now because of the culture of the SSA with how they treat people under 50. So I'd have to look at the briefs to figure out if it's a new file gig or go to appeals counsel, but send it over. I'll take a look at it,
Yeah. Thank you so much. I appreciate you more than you can even know because I can't talk to anybody. And it's just, thank you.
Yeah, of course. Of course.
Such a good person.
Thank you.
I am so grateful.
Thank you.
You have a wonderful day and a wonderful July.
Thank you. You have a wonderful night and a happy 4th. Yeah.
Thank you so much. Thank you.
Thank you. Bye-bye.
Bye-bye.
Hi, this is Attorney Walter Hnot. We are live. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Hi, can you hear me?
Yes, go ahead. Yeah.
Okay, sorry. I had my TV on and I didn't know you picked up.
Sure.
Okay, so I'm going to try to do this without being confusing. So my daughter, I'm a representative payee for her, and she's going to be 22 in August.
Mm-hmm.
Prior to her coming 22, she was found disabled as an adult for SSI. Okay. So I guess what they're trying to do now is they're trying to add her as a disabled adult child onto my account.
Okay.
So I want like to know, like, is that what, can they do that? Number one. And number two, they're saying that there's a whole bunch of rules that are being changed and that they may be able to go off of what you were just saying about what decision was made prior to age 22.
So, okay, a couple of questions in there. The first one is a DAC prior to 22 attachment to your benefits. I'm assuming you are disabled, retired, and not dead. So, yeah. So you're
disabled.
You're disabled. Okay, cool. So, yes, she can attach. Yes, it will likely increase her benefits. The reason they have that program is because if a child basically is disabled between 18 and 22, kid's not likely to go and do work. And if they're not likely to go do work, they allow them to attach to their parents' retirement benefits to go ahead and pull from the trust fund and get paid a little bit extra money. So
they told me that they were trying to switch it from her being on SSI to being off of mine for, SSA versus the SSI.
Mm-hmm. Yeah, sometimes they do a hybrid allowance, sometimes it's full. But bottom line is, okay, so what is your legal question then?
So, I don't know if you can answer this or not, but so what do I have to prepare myself for? Because they're pretty much saying that I have to reapply for her.
Well, no, you're not So, okay. So that was so cute though, when you're like, what? How do I prepare for this battle? And I'm just like, I'm in my head when you said like, how do I prepare? I'm like, well, an umbrella. You're gonna need an umbrella. It's gotta have polka dots. It's gotta be nice. So, but that's part of my thing. But so first thing is, for DAC benefits, you're supposed to apply, and basically, if she's eligible, they will attach her to it. SSA. For PDF, if you type it into Google, is the application for child insurance benefits, or what we call DACs. So if you're wondering like what questions are going to be asking or what form you need to file, it would be the SSA -4-BK. You just Google, it'll pop up as a PDF. That's what you fill out. That's what you submit. And then the child will basically get a higher benefit. Now, look, if the child's disabled through, kid zone into quasi-adult zone, 18 to 22, then to be fair, you're going to be obviously the payee throughout, you're going to continue to be the payee, which means the child's just going to get more money. You're going to be able to distribute more money and use more money to upkeep the child who's now an adult.
See, that's where my confusion is at, is that she was already found disabled as an adult, right, at the age of 19.
Mm-hmm. Yeah,
and now they're trying to put her as a change for this. And my question is will I have to go back through all the medical and all those types of things? Like the whole process seems like I have to do it all over again. No.
It's too recent of a decision, A. And B, their question is not of, realistically, in this sense, disability. Their question is of, does she have a parent that meets the elemental requirements to be able to give her additional benefits, in which case you're disabled. So yes, you're going to tap into your retirement benefits. Doesn't lower your retirement benefits. You're still getting the same amount. It's just she's going to tap into, what you paid in over those years. Technically, it's not even that. She could technically pull more from what you paid in throughout all those years in your life. But
right.
Yeah. So no,
I'm talking more about more as far as like the paperwork and what I'm going to need, because they basically told me that I would have to start the process, like a brand new application is what they told me. And I would have to give them the information all over again about her medical and all those types of things, the same things that they asked to begin with when they first asked for her eligibility at that point. So that's where I'm confused.
Yes, they're going to ask for all that stuff. But in practical application, when it gets to DDS, to actually go through the processing of it, they're going to quick go through that because they have a recent adjudication where they refound that child disabled on SSI benefits at the adult level. So as a result, they're just going to use that medical standard, and then they'll basically go ahead and just look at the non-medical requirements, which are the technical requirements of the parent. And once you pass that, then they're just going to slide this thing through.
Okay, that's what I was wondering, because I was told that, they were going to use the medical determination prior to age 22 at some point in the Social Security, since things are changing, but I didn't know when that was actually going to happen.
Sure. Yeah. No, this will be a very different, it's still going to take a while because they're, super overloaded, but this is going to be a very different application process compared to when you initially filed. Yeah. It's going to be easy peasy compared to that. Yeah.
All right. Well, thank you so much. That's what I was curious about. Thank you.
Absolutely. You have a wonderful, wonderful night and a happy 4th.
All right. Happy 4th of July.
Thank you.
Good night.
Thank you. Good night. Bye-bye.
Bye-bye. Bye-bye.
Hi, this is Attorney Walter Hnot. We are live. Go ahead and mute the computer or TV on your end. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
What is your legal question? Go ahead. All right, I had talked to you before.
Oh, you gotta mute the computer or TV or whatever it is in the background. That way we're good to go. Perfect.
Whatever it is in the background, that way we're good to go. Yeah, it's on my cell phone.
Oh, okay. So you just got to close the cell phone app that has me on YouTube, and then just go ahead and talk through the phone. That way you'll be able to go ahead and hear me without the additional audio.
Or so hang up. So push the hang up.
Well, yeah, you wanna X out of the YouTube video that you're watching it on your phone. That way we can just talk through the phone. Or you can do that. Let me see if he calls back. Hold on. And this will be the last call because it's late. It's like 1:28 a.m. And this is supposed to be like a 30-minute yada yada. But then that thing happened. And I was like, because I didn't know what that ruling was. I have to go read it, find out what cookies exist in that jar. Let's see if he calls back. If he doesn't call back, then that'll be the end. Also, Scott Jones, thank you for the appreciation membership. And YYZZ for the 99-cent donation. That's absolutely awesome with a little face there. We also have Theodore with the $5 donation. Theodore has been in a lot of videos recently. Let me see if this is the same person right here. Okay, so good sir. Yeah, so you have to close out the YouTube app on your phone.
Okay, can you hear me now?
I can hear you, but the YouTube app on the phone, maybe it's gone now. Let's see. Is it gone?
It's gone now. Let's see.
Nope, it's still there. You got to go ahead and close the YouTube app out on the phone, or go into a completely different room with the phone being a different device. Because remember, we're getting a feedback loop. It's showing me live and it's, over the phone.
I'll mute it on the phone.
There you go. Can you hear me okay? If you're talking, I can't hear you. So you have to close out the YouTube video on the phone and unmute yourself on the phone call. Let's give him a second to see if he can make that happen. Come on, you got it.
You can hear me now, but I don't know how to hear me now.
Okay, so let's do this. Next week or next Tuesday or Thursday, just call me from a different phone than the one you're watching on.
Well, I had a quick question. Can I ride a mountain bike for help? I'm a veteran and I'm disabled.
So basically, it depends, because if your disabilities were musculoskeletal related, and if you don't have a note from a doctor saying that you need to do this for basically medical treatment, then you're putting yourself in danger of them saying that you have more capabilities than you actually do. So if you're riding a mountain bike and the doctor said, that it's a good idea for your therapy, cool. If the doctor said nothing and you have musculoskeletal issues with your back, then the compression of your back going up and down on a mountain is obviously going to make it look like you're not actually truly severely disabled.
Well, listen, thank you. You accepted my last phone call. I'm a hillbilly from Kentucky, and I thank you for it, and God bless you for doing this.
Absolutely.
I gave you a $20 super chat earlier.
Oh, very cool.
And, so, listen, I got a lawyer up there. I used to make $80,000 a year, and now I'm zero.
Okay.
So thank you so much, sir. I love you, and God bless you.
Thank you, good sir. You have a wonderful, wonderful night, okay?
Yes.
Thank you, sir. Thank you. Bye-bye. So yeah, that's the feedback loop. So if you have a video on your phone and then you answer the phone call, then basically it's getting two audio signals that are feeding back into each other. Here we go for the final. We'll do one last call. Here we go. Attorney Walter Hnot, Disability Resolution PA. We are live on YouTube. What is your legal question? Go ahead.
Hello.
Howdy, good sir. What is your legal question? Go ahead.
Yeah. So, if you are out of the country, how do you do Social Security?
Like, how do you file? Well, you file online, and then you notify them as to where you're at. And then some of the places they have basically an actual like SSA office, and then some of it you just go through the consulate. But a lot of the stuff you just basically do through online, and they mail you the paperwork directly to your house. So a lot of the stuff now, instead, it used to be more consulate-y. Now it is more of like they have a division that handles a lot more of external stuff. To be fair, a lot of it, the reason why there's so much of a transition internally is that a lot of the VA people moved to like Thailand, Vietnam, stuff like that. And, because obviously islands and beautiful people, wink, wink. And as a result of that,